We're on the record this morning in the matter of Ezekiel Wardell. Mr. Wardell Gibson is the petitioner in this action. Respondent was Denise Martin. I see both parties are present. This was initially came before the court in August of 2008 on a petition for establishment of parentage, and included in that petition was a request for the determination of a residential plan or parenting plan for the minor child and for child support for said child. This case has been pending for over 3 years now, and I know during the pendency of the action there was some discussions about father being established as Ezekiel's natural father, and from my review of the file, Ms. Martin was not denying that. It was a matter of father contacting the department to have the birth certificate amended to reflect that he was in fact the natural father. Wasn't that your position, Ms. Martin?
Yes, sir.
Months ago? Okay. Have you done that, sir?
I believe that has been done.
Okay, so there's no question then as to whether Mr. Gibson is in fact Ezekiel's father. Correct,
No,
Ms.
Your Honor,
Martin?
there's no question.
All right. Mr. Gibson, any question?
There's no question.
All right, so that part of the petition that was filed is established. Okay, so the next determination is then the residential schedule for the child, and that's where we begin today. Both parties have been before me on numerous occasions. Just in reviewing the file, there have been at least 20 hearings in this case since it started. They know what I expect as far as their conduct and decorum in the courtroom. So any questions about that, Ms. Martin?
No, Your Honor.
Okay, well, first things, I don't allow water bottles in my courtroom, so remove that. There's water there if you want it. During breaks and recesses, you can have your water, but during the court proceedings, I don't want any accidents happening where bottles will spill on tables.
I understand.
Okay, any questions before we get started? Mr. Gibson.
I have an opening statement.
Okay. You're entitled to do so, so go ahead.
Okay. First of all, good morning to you, Judge Rowley. I appreciate your diligence over the last 3 years and perseverance. As you know, my name is Wardell Donald Gibson. I am the petitioner and biological and paternal parent of Ezekiel Wardell Gibson. My prayer to the court is for an order awarding immediate permanent custody of my son Ezekiel Wardell Gibson to me forthwith. First, I believe that you have a new motion before the court demanding the court to find Ms. Martin in contempt for once again absconding with my son to places unknown to the court or to me in a violation of the court's order to notify the court and the father when and where Ms. Martin moves. The reason we are here to begin with is because of her blatant thumbing her nose at the court's orders and relocating and taking trips outside of the state of Oregon to Washington and California. After being told by you, Judge Rowley, that you were her king and she is not to make any decisions concerning the moving or relocation of Ezekiel out of the 4 counties surrounding Portland, Oregon, Multnomah County, Clark County, Washington County, or Clackamas County. She's done this repeatedly and has done it again. Further, the court also ruled that Ezekiel was to be continually enrolled in school, and unless he was enrolled in the last 10 minutes, he's not been enrolled in school. He's not going to school. And this is, I take great exception to, based on a letter from Bachman Creek School that placed Ezekiel as a gifted child. This letter was received on May 26, 2010. Was written by Ms. Ken Blair, Instructional Coordinator for Gifted Educational Coordinator, and Charlotte Morris, Principal of Bachman Creek School, is listed on the letter. And I think you have a copy of this.
Let me add this at this point, Mr. Gibson. You quoting from letters without being able to admit them into evidence at a later date?
We have,
Be a problem,
there is,
so-
the letter is an exhibit that you have in your possession.
The fact that you give something to the clerk does not make it part of the record and does not make it admissible.
Okay?
Letters from third parties are hearsay, so unless you can have the person who wrote the letter in court, they are not admissible exhibits.
Okay, then
Do
let
you
me
understand
read.
that, Mr. Gibson, do you understand that point of law?
I understand.
Do you understand that point of law?
I think so, Your Honor.
All right, thank you. Go ahead, proceed then.
Okay, it was brought to my attention that Ezekiel had been placed in a gifted program, and the fact that he's not in school is not a good thing. Your order was that he attend school, and she was to enroll him in school, and she has taken him out of school for who knows what reason. We have our belief as to what the reason is, and that will come up and as we examine this case as part of our caseload. Secondly, the second motion that you have concerns the testimony of Mr. Richard Gill, and I would like to move that the court allow Mr. Gill to assist my pro se petitioner plaintiff case throughout the trial. And in order to do that, I'd like to call him as a witness first to give his testimony, let Ms. Martin cross-examine him, and then after that, I would like for him to be able to assist in the proceedings here.
I'm sorry, would you restate that, please?
Yes. Mr. Richard Gill, I would like to call him, first of all, there's a motion before you that allow him to assist me in this case. Second of all, in order for him to do that, I would need to first call him as a witness, as he has a testimony that I believe is germane to the court. So I would call him as my first witness, and then after that, he would be able to assist me. She would be able to cross-examine anything that he might want to say.
Is he included on your witness list, Mr.
Yes,
Gibson?
yes, he is.
And when was your witness list filed?
The witness list has been filed and amended several times.
So when's your most recent witness list filed?
I was told on Friday by the court when I had an amended list. I think he's on the amended list already.
Okay.
It's
Can
been
you tell me
filed with
when
the
that
court.
was filed with the court, Mr.
I'm going to say last Tuesday or Wednesday. Tuesday, I believe.
I haven't received a copy, Your Honor.
Miss Martin was
Cell phones off, please.
Miss Martin.
Excuse me one moment. Let me see if we can find that. Ask the clerk to see if there's anything in the clerk's file from last. Do you have a conformed copy of that, Mr. Gibson? Your most recent witness list? I have one from Ms. Martin dated August 24th.
Yes, I do. And this was the amended was October 31st.
October 31st.
Then there's another one amended 11/4, and then one that we have right now for 11/7. He was either on the 10/31 or the 11/4.
Page 179 in the file, it was filed 10/31.
That wouldn't have made this file, would it, if I've had the file, right? That wouldn't have made this file.
No, so it will probably be in Liberty since it's already entered and hoping it's in Liberty. Let me check. If it is, I can get it printed for you.
Okay, on February 17th of 2011, we had a hearing. At that time, we discussed potential witnesses at the trial. I told Mr. Gibson if he's going to have Mr. Vetter and Dr. Johnson appear at trial, then he needed to give Ms. Martin copies of their reports. If the parties want to change their witness lists, they need to amend it and file a copy with the other side. If a party is not on the witness list, that person will not be able to testify. So any last-minute witnesses you wish to call at this time, Mr. Gibson, will not be allowed.
So Richard Gill would not be a last-minute witness, because he was on
Sir,
the...
that was my order from months ago on this ongoing issue about witnesses. So I told you then, months ago, that you would not be allowed to call witnesses the date of trial that weren't disclosed.
It was disclosed on 10/31.
Well, I did not receive an amended witness list from you, Mr. Gibson.
The original copy was filed October 31st, 2011. The amended was filed October 31st, 2011. It's stamped on here. I would understand anything that would have come that we wanted to do today. You would rule against that, but as far as 10/31,
Okay, I've been handed an amended witness list by the clerk, filed the 31st, and 3 people are added: Charles William, Richard Gill, and Veronica Miller. So those people are on the amended witness list as of last week.
thank you, Your Honor.
Now, what attempts did you make to provide Ms. Martin with copies of your amended list?
3 different attempts. 2 last week after we filed this on October 31st. So on November 1st and November 2nd, we tried to serve Ms. Martin at night. Nobody answered the door. Again on, I believe, on November the 4th or 5th, Aaron Boladula went during the daytime and tried to serve her and found the home to be vacated.
What day was that?
I believe that would have been November 4th or 5th. And it was vacated. Let's see here. And we came back to the court. That would have been Thursday. And on Friday, we came back to the court and to notify the court in your office that Ms. Martin had vacated the premises. There was no furniture in the house. The floors were bare. We were not able to serve her, and we notified the court that next Friday.
What address was that, Mr. Gibson?
Her address in Tualatin, Oregon. The last known address of her, which would be
One she provided to the court on May
That's correct.
26, 2011?
on when?
On May of this year,
That's correct.
the one on 55th Avenue in Tualatin?
That's correct.
Okay. Any response then, Ms. Martin?
No, Your Honor, I have moved. I am reachable by mail because I have put in my forwarding address, but I have no objections.
Where did you move to?
622 Southwest Alice Street in Portland, 97219.
972.
19.
When did you move?
2 weeks ago. And my understanding of the law is I had 30 days to notify the court, and knowing that we were going to be here today, it was an extra trip to Vancouver in a very busy schedule.
And what law are you relying on that gives you 30 days to notify me that you've moved once again?
I'll have to hunt for my documents, but you told me that if I moved, I had to notify the court. And when I looked up the statute, it said you have 30 days once you move to file with the court.
What statute are you referring to?
I don't know. That was my understanding of the law.
Your Honor, the reason that we're here to begin with is,
No, I'm sticking to one issue at a time at this hearing, okay? So let's focus on whether Mr. Ellis, Mr. Gill will be allowed to testify, and the answer is yes.
thank you, sir.
Okay? Now, you said that you wanted him to testify?
My understanding is that if he testifies, she has a right to cross-examine.
Correct?
So I would like to call him as my first witness to let him testify to those things that are pertaining to this case, and then allow her ability to cross-examine him, and then I would like him to sit with me to help me with my case as he's helped to prepare.
No problem with him testifying like anyone else, but as far as sitting at council table, that's not permitted.
Okay?
Only counsel and pro se's are entitled to sit at council.
My understanding was, because it was pro se, that I could allow somebody to assist me to make sure that I have my things in order as I need them and so on and so
Won't be
forth.
allowed,
Okay.
nor for her. Okay, Mr. Vetter and Mr. Johnson are both subpoenaed to be here this morning. Mr. Vetter at 9 o'clock, I believe. Is that correct, Mr. Vetter?
Yes, Your Honor.
Do you have other appointments at your office this morning?
No, because I received a subpoena last Thursday, I believe. So I cleared it to be here this morning.
Okay, as Mr. Vetter is the subpoenaed 9 o'clock witness, he will testify first.
That's perfectly fine with me, Your Honor.
Dr. Johnson, when were you subpoenaed for?
I was subpoenaed for 10 o'clock. I was hoping to discuss that with the court. Prior to my testimony, I received a subpoena just to come on Wednesday.
Would you approach, please, so that we can pick you up on the microphones? And it's Dr. Kurt Johnson who was subpoenaed to testify in this matter.
I communicated with, and that subpoena requested a certain document which I have brought with me. I indicated to Mr. Gibson, I think on Thursday, the arrangements that he would need to make to have me testify. Those arrangements have not been made. And I'm particularly concerned about testifying in this matter unless the costs have been taken care of. Given that when I did produce a report, there was a complaint filed with the Psychology Board, the Washington State Psychology Board, and although that was investigated and found to be baseless, I'm a little concerned with testifying in a manner that might be adverse to Ms. Martin, as it would be seen thus as something of a favor in this situation. So I'm a little concerned about what to do about this, but I did come today with the document that was requested.
Mr. Gibson?
Yes, I had talked to, as he said, I've talked to him a couple of times. He was going to, the last conversation I had with Dr. Johnson was that he was going to check out those things that he just said that he had a concern about and was going to give me a reply back. As far as what he is required for me to be able to pay him, I've made arrangements to have that taken care of, although I cannot do that until the 19th of this month, and he'll be paid in full.
Any response from you, Ms. Martin?
I'm not understanding Mr. Johnson's concern, other than the money, but it seems to be something else there I didn't understand. His concern, or the word favor, or what he's relating to you. So I can't respond.
One more time for the record, Mr. Johnson, Dr. Johnson.
I'm concerned about not having my fees paid in advance I'm concerned about that, given that my testimony could be seen by Ms. Martin as adverse to her, and be seen as in part related to the fact that she made a complaint against me to the Washington State Board of Psychology examiners.
So if you're
It would not be a normal. I'm sorry, Your Honor.
I get it now, Your Honor. My response is, if he's willing to testify and pray that he'll be paid, I don't have an objection.
Ms. Martin's in case she has no objection, Dr. Johnson, so you'll be testifying at 10 o'clock.
All right.
Nothing further. Okay, Mr. Vetter, please come forward. Raise your right hand, sir. You solemnly swear and affirm the testimony you're about to give will be the whole truth, so help you God?
I do.
All right, please be seated. State your name and your position, please.
Yes, Terry Vetter, last name spelled V as in Victor, E-T-T-E-R. I'm the Family Court Services Coordinator for the Clark County Superior Court.
And were you ordered by this court to do a family court evaluation regarding this family?
Yes, I was.
And when was that?
Well, I interviewed the parties 3 years ago and provided a report 2 years ago, and then a supplemental oral and a small written report approximately 2 years ago. I'm just going to check that, looking at my records, the last written report. My original report was filed August 5, 2009, and my supplemental report was filed August 13th, 2009.
Okay. All right, Mr. Gibson, if you would.
Good morning, Mr. Vetter. I appreciate you attending this morning. The court, if we can go back a little bit before that time when Ms. Martin was served at the airport as she came back to Oregon from Tucson, Arizona, she appeared in this courtroom and testified that she was unprepared for her testimony in that courtroom. The judge gave her a little bit more time. Then Commissioner Scheinberg.
Okay, Mr. Gibson, no background information.
Okay.
Ask a direct question of the witness. If you would, please.
Could you tell us the events that led to you having to do the work that you've just said that you've done? What was the reason for the judge ordering you to do what you did?
According to I received an order for the parties to appear in family court, and the note that I received was for an initial parenting plan, and that was dated September 17, 2008, and to look into DV and mental health issues.
And you did that, and who was it that you did this evaluation? I mean, who was it that you employed to do this work?
Well, some of it I did myself, but I also, there was a request later that Dr. Kirk Johnson become involved and assist the court.
Okay. And so did he follow up on what he was commanded to do by the court, as far as you know?
Yes.
Okay. And did he report back to you his findings?
Yes, he provided a written finding regarding the mother, Miss Martin, and he provided oral findings to me regarding yourself.
Okay. Were there any other professional or lay people that you were assigned to take a look at? For example, were there any background checks ran on anybody in this?
Well, I'm able to do that myself, so
Okay.
no, I did not hire anyone else to do that.
Okay. So there was a psychological report done on Miss Martin, you're saying, and Dr. Kirk Johnson. Was there anybody else involved in that from the Vancouver Guidance Clinic, as far as you know?
Well, I received Dr. Johnson's report, and so whatever's contained in the report that I provided to the court, it'd be included in Dr. Johnson's report.
Okay. And Dr. Johnson is here. He can speak to that.
Right.
Was there an evaluation done on myself, Wardell Gibson?
I received the background on that is there was a temporary order hearing. Commissioner Scheinberg wanted some additional information regarding yourself on a temporary basis, and this was, again, 2 or 3 years ago. It's my understanding that what Dr. Johnson did at that time was what I would call, I mean, he can testify to it, but what I would consider a mental health status investigation that addressed some of the DV issues and the other and mental health concerns about placing the child in your care.
And what was the result of that finding?
And my notes and my report to the court indicate that Dr. Johnson had the opportunity to review a previous evaluation that one of the findings in that was a personality disorder issue, that Dr. Johnson said he could understand those issues, but insofar as placement of the child in your care, he didn't have any concerns about the child being in your care.
Okay. Also, your compilation of information from that report, did you also do a criminal background check on Mr. Gibson, myself?
Well, at the time, I would have done that, yes.
Okay. And did you find anything that would lead you to believe that I would be any kind of other than a good asset to my son? Is there anything there negative or criminal that raised your eyebrows?
Well, what I did find was a history of I believe it was contempt actions based on, or on civil actions based on domestic violence situation, and then there had been some litigation in Oregon over that. And I think I addressed it in my report, that there's conflict in the family, and that's always a concern. But in terms of statutory limitations on an ongoing pattern of domestic violence, criminal domestic violence, I didn't discover a history of criminal domestic violence as such as I would recommend limiting a parent's either their decision-making ability or residential time with the child.
Isn't it true, Mr. Vetter, that you didn't find anything? I mean, the respondent here has claimed all kinds of abuse issues. Isn't it true that you didn't find anything to substantiate that?
Well, as I just stated, I did find some history of a contempt proceedings in Oregon, but in terms of a lengthy criminal history of domestic violence, I did not discover that, no.
Okay. So let me ask you this. Mr. Vetter, you have written a response to the court based on your findings and based on all the information and data that you were collected from different sources. And so my reason for calling you here today is because you seem to be the other than, of course, the judge, the general or lieutenant in Army terms, to get all these things done. And so what I'm asking you is, do you feel like you did what the judge had commanded you to do to the full extent of what you were able to do?
At that time, yes.
At that time, okay. I have no further questions at this time, but I reserve the right after her cross-examination to be able to question him again.
Okay, that'll go without saying, Mr. Gibson, so you don't need to ask that after every witness.
Okay.
You always have the right of sur rebuttal. Okay, Ms. Martin?
You mentioned that we were interviewed in September of 2008, and you filed your first report on August 5th, 2009, 11 months later. Is that a typical time frame for your job?
No.
Why did it take so long with a child at risk?
There were a number of issues going on between the parents that took that much time. I was also waiting for information from Dr. Johnson, and that's the reason that it took that length of time.
So for 11 months, you were concerned that the child was at risk, but it's just how long it takes, I guess.
I don't believe I testified that the child. I believed that the child was at risk.
Well, you testified that he should be turned over to Mr. Gibson, which he was after your testimony, even though I'd already asked for a continuance. You were allowed to testify, and you told Ms. Scheinberg that you felt that the child was at risk in my care after 11 months of sitting on that information.
Well, it may have taken 11 months, but it was not sitting on the information, and the recommendation was based upon kind of an unstable living situation, allegations and concerns about absconding with the child and not being around with the child. And so up until that time, it was my observation that the parents had been in front of the court, and it's the commissioner or the judge's duty to determine where the child lives on a temporary basis. But at that time, without being able to corroborate living situations and instability, that was my recommendation, yes.
You recommended anger management for Mr. Gibson. It was never instituted, but why did you feel that was necessary?
Well, part of it was because of, as indicated, I looked into the Oregon contempt situation. And if my recollection is correct, there might have been a recommendation that Mr. Gibson participate in that, and with the conflict between the parents, and I think there were some outbursts in the courtroom that were documented. It was my opinion that that's a course of treatment that would be helpful to him.
When you testified in front of Commissioner Scheinberg that day, you listed 3 different police agencies or government agencies that you had searched looking for background information on Mr. Gibson, and that he was, I quote, clean as a whistle. You never mentioned that day that you had found anything in Oregon. You never mentioned Oregon, even though the child had been born there, spent most of his life there, and was currently living there. You did not read anything into the record that day about his Oregon OGIM file. Did you feel it was not important for Commissioner Scheinberg to know that information?
Well, I don't recall testifying the way you categorize it, so I don't believe I would have used the term that he's clean as a whistle. My recollection would be that there would be I would have mentioned the civil, but in terms of criminal, as I testified today, I did not find any criminal domestic violence charges.
So a conviction on contempt is not considered a criminal matter?
No.
Okay.
Not in my opinion.
This is a case where, as you mentioned, there were accusations of domestic violence. Mr. Gibson had 7 entries in 5 years with his name on one side of a restraining order or another in the county where our son was born. You didn't consider that, you didn't give that any weight, that my story might have some validity, that's just a non-issue for you, Mr. Bennett?
No, that's where I go back to. Those were civil matters, not criminal matters. And I did. I think I spent a good portion of my report addressing the difficulty that this type of conflict represents to the child. So I believe I addressed that in my report.
The only restraining order on record with my name on it is the one that I took out against him. Was that your finding?
I don't recall, but that's probably accurate.
And so although you could not find adequate criminal record, the fact that 7 different people had to take this man to court or face him in court because they couldn't deal with their issues with him didn't support your concern that maybe I was having challenges with this gentleman behind closed doors?
I addressed those. I believe I said there is conflict between the two of you, as not only represented in your declarations, statements, but in the behavior in the courtroom and the requirement of Dr. Johnson to be involved and to do an assessment as to, how that, if the child's welfare would be in danger in if he were with Mr. Gibson. So that's how those issues were addressed.
I understand. In your experience as an expert dealing with families for 20 years at least, when a woman who claims that there's domestic violence hits the door, can you imagine that she might have to leave without money and transportation and that road might be bumpy? She might not be stable trying to flee an abusive situation with a child and the other partner had the money and the home and the car all locked up. Can you imagine that might create an unstable home life for a while trying to flee an abusive situation?
Yes.
Thank you. I have no further questions, Your Honor.
Okay, Mr. Gibson?
Mr. Vetter, referring to the 7 so-called domestic violence incidents, when you investigated, did you see that they had all been dismissed?
I don't recall at this time. I can look and see if I have a printout of that in my file.
All except for one had been dismissed. That one was when I thought that the...
He needs to testify on those issues.
Okay, I can.
Gibson.
I do recall, if I can, maybe I even have it in I probably addressed that in my report about the
They would have had to have been with Corinne Michelle Gibson, Joel Jack Gibson Jr.
What I found significant is what I included in my report, and if I can, and that's contained on page 3, beginning on line 9. And in that, I state that paragraph, Both parents described being involved in the courts in Oregon for a domestic violence incident. The mother describes the father as being violent, particularly when he is under a lot of stress. The father described the incident as an argument over a television set and that he got in trouble with the law when he violated the no contact order during visitation with the child. The father had a mental health evaluation completed by Dr. Mark Clark as a part of his probation requirements in Oregon. The evaluation concluded that the client appears to have no significant emotional disorder or mental illness. A copy of that evaluation is attached to this report, and that's Dr. Clark's. And so from the records that I looked at, those were the significant issues that formed my opinion in the assessment section, where I go into great length talking about my interpretation of the conflict between the two parents.
Mr. Vetter, in how many years have you been working at the capacity you have at this court?
3.5 years.
3.5 years. Would it be fair to say that this is not your first rodeo with these kinds of events?
No. I mean,
okay. In other words, you're experienced when accusations of abuse are slanderously leveled at different people all the time. That doesn't mean that they're so.
Correct.
Okay. So if there's a report, if there's a mental health report, which, again, Dr. Kirk Johnson will testify to, that talks about delusions of grandeur and grandiosity and all these kinds of things as a part of a psychosis or a part of a mania or hypermania, would those kinds of claims be out of the ordinary for someone that has this kind of psychological profile?
You know, I don't have the background to make that assessment. That'd be a question for Dr. Johnson.
Of course, but it wouldn't be the first time that you've seen something.
If I could, you know, I spent in my report a big portion of my assessment talking about the type of relationship. That's something that I can observe and have had training in domestic violence and trying to keep up with the literature on domestic violence. That it indicated to me that this was a relationship of people who whatever their backgrounds were, have a difficulty resolving their problems, and that led to the amount of conflict that leads to the amount of allegations that are going back and forth between the parents, and that in the long run that's detrimental to the child.
In your report, in your investigation, did you uncover anything that would lead you to believe that Ms. Martin had been abused in any kind of a battery kind of a way, any kind of a physical violence of any kind at any time? Did you discover anything like that?
I don't recall that, no.
Okay. If there had been something like that, probably you may have a better recollection?
Probably.
Okay. Isn't it true that in your investigation, Ms. Martin claims to have all of this abuse? Did you, in your background check, discover that she was a third-degree black belt Taekwondo martial arts expert and had been on the U.S. Olympic team and had been trained for presidential security? Did you uncover that?
If I can, you know, I hate to keep repeating myself on this, but my assessment on the domestic violence was not an assessment that one person was battering or physically damaging the other person. My assessment on the domestic violence was there was such an inability of the two parents to resolve their problems that it led to arguments, it led to the outbursts in these courtrooms, I'm assuming the Oregon courtroom, that there needed to be something to be addressed in order to have the parents resolve their issues independent of one another so that the child is not exposed to that level of conflict. Because domestic violence is not just one person battering another or one person being a black belt and attacking the other, because that was, as you asked me, that's not the situation that I found in this case. This is a case of domestic violence where people can't resolve their problems when they get together to try and do that. It usually ends up poorly, either recriminations or arguments or whatnot, and that is not beneficial to the child. That was my finding.
So then, if I can try to illuminate and understand what you just said, a person can claim domestic violence because you disagreed on what flavor of jam to put on some toast. And if you like grape and she likes strawberry and there's an issue there, if there's an argument, then a person that has a psychological profile that you know of, because you've read Dr. Kirk Franklin's report, she then could say anything that might lead to some kind of an accusation of abuse simply because in her psychological profile and being so afraid and intimidated and terrified because she doesn't like strawberry jam or like grape jam because of her psychosis.
Objection,
She
Your
can say
Honor.
anything.
He's asking for an expert opinion. This witness has stated that this is not his area of expertise.
Objection sustained. Next question, please.
I have no further questions at this time. I would like to call him back after Dr. Kirk Johnson's testimony, if that would be allowed.
Anything further?
No objection.
I have a question I'd like clarified, a comment that you made, Mr. Vetter. When Ms. Martin asked you on rebuttal about the time frames in the interviews that were conducted in this case, the initial interview being September of 2008 and the report submitted in August of 2009, is that significant to you one way or the other in that the initial interview was over 3 years ago and the report was submitted 2 years ago?
Your Honor, it is significant to the extent that I don't know, I did not follow and I haven't been involved with the parents since that time. To that extent, it's significant because I don't know what's happened over the past 2 years. But as to at the time, in the delay between the 11 months between being appointed and interviewing the parents, waiting on Dr. Johnson's report, following what was going on in court at that time, I don't believe the 11-month delay was significant at that time when it was submitted.
Anything from the parties in regards to my question?
No, Your Honor.
Thank you, Mr. Vetter. Step down.
Your Honor, am I excused, or do you want me to wait around in case I'm recalled?
You're excused for now, and in the event you need to be recalled, you'll be summoned from your office. Thank you. Okay. Dr. Johnson, Mr. Gibson?
Yes, I'd like to call Dr. Johnson, please.
You go get him, please. It's probably in the anteway.
I can check.
Thank you.
Your Honor, I have a exhibit list, and I would like to be able to have my copy of the exhibit list that was handed over, and that would be item number 30, 29,
What are those, Mr. Gibson?
This would be the psychological assessment of Denise Martin. That would be exhibit number 30. A copy of Dr. Johnson's report That would be number 29. And mental health evaluation report, excuse me, copy of the family court services. What I would like to see is the psychological assessment of Denise Martin, identified as exhibit number 30, and a copy of Dr. Johnson's report from 7/12/09, which should be number 29.
Those are both right here.
Well, he hasn't testified yet, has he?
No, I would like, that's the report that he's going to testify, and I have questions regarding that report to refer
You
to.
don't put the cart before the horse.
Okay,
Horse testified.
I understand. Thank you, Your Honor.
He refers to his report when he testifies, and then at the conclusion of the testimony, you make an offer for the admission of any reports that the witness testifies to.
Okay. There was just some information in the report that I wanted to refer to refresh my mind as to what I wanted to ask him. That would be the reason for that.
Are you requesting that Mr. Vedder's report be admitted? 'Cause
Yes, I am.
You mentioned 4 reports.
I'm requesting that Mr. Vedder's report, which would be the copy of the Family Court Service Report, which is identified as number 27. That would be from Terry Vedder. A copy of report from Terry Vedder, file 2/22/11. That would be item identified as number 32. And a letter and report from Terry Vedder, identified as number 33. Be entered into evidence.
So number 27, number 32, and number 33? That's what you're asking to be admitted?
32, 33, 27. Yes.
Can I see those, please?
Also,
One moment, please. Exhibit 27 is Mr. Vedder's family court report. However, the copy that was asked to be marked has 14 pages, and there's no signature page on that document. So that document is not admitted.
really?
Number 32, a report dated February 11th, 22, 2011. A 2-page document, and then a supplemental is attached to it. That is admitted. Mr. Vedder's signature is on that document. And then there's number 33 here. Can I see 27 again?
Yes, Sean.
It's a copy of the August 5th, 2009 report, and it does have a signature page. And then it has copies of various segments of that report attached to it. I don't know why. But For example, there's page 3 through 14 of that August 5 report with yellow highlighting on some of the pages. Which are not admissible. So the first 15 pages
33.
of 33 are admitted.
We're making a new sticker.
So if you want to just take this sticker and put it on there.
That won't work, unless you can get it off without tearing the paper. I just made it
Okay.
really loud.
And make that 30,
3A.
yeah, 33A, because I'm not admitting the offer 33. And 27 is not admitted because it's part of 33A now. Okay, that's the one.
This one was denied, so
Yeah,
it's
'cause
over
it-
here.
It doesn't have a signature page on it.
That would be 28, you're saying is not allowed?
27 is not admitted, no signature page. 33 is not admitted because it has highlighting on additional pages.
33A.
But 33A is admitted, which includes Mr. Vedder's August 5 report in its totality, 15 pages, and signed by him.
August 5, 2009, is that correct, Chairman?
Right. Anything further, Mr. Gibson?
At this time, I think that's what I need
Okay.
to,
It's Dr. Johnson. Dr. Johnson's here, so call your next witness.
These are,
I call, Your Honor, Dr. Kirk Johnson from the Vancouver Guidance Clinic.
All right. Do you solemnly swear and affirm the testimony you're about to give it be the whole truth, so help you God?
I do.
All right, please be seated. All right, please state your name, please.
Christopher Kirk Johnson.
All right, your witness.
Good morning, Dr. Johnson, and believe me, I appreciate your appearance here under difficult circumstances. There was a time when, back about 3 years ago, when this court had Dr. Terry Vetter appoint you as a to do a psychological evaluation on Miss Denise Mae Martin. Do you remember having that, having been told to do that by Dr. Vetter?
Correct.
Okay. And could you kind of give us an idea of when you do a psychological evaluation, there are some well-recognized in the psychological and psychiatric world certain kinds of tests that are administered so that you can evaluate certain kinds of conduct, emotional conduct, and other kinds of things. Could you kind of enlighten the courtroom on what kinds of tests and observations you employ to be able to determine her mental state of being?
The evaluation included the interviews of Ms. Martin, included two psychological tests, two standardized tests, the Minnesota Multiphasic Personality Inventory, second edition, and the Milan Multi-Actual Clinical Inventory 3. The evaluation also involved an observation of Ms. Martin with her child, that observation having been conducted by Dr. Williams. And then the evaluation also included the review of certain documents.
Okay. And you mentioned Dr. Williams. Now, Dr. Williams at that time was employed at your clinic, is that correct?
He worked as a contract employee at the clinic.
Okay. under your guidance, under your authority?
Correct.
Okay. And there, as I was reading the report, and I've read it a number of times, it was quite extensive. Could you elaborate on just what some of those things were? What kinds of criteria? And you mentioned the kinds of tests, but what do those tests involve? What do you actually do? What kinds of questions are asked? I mean, how do you evaluate the mental capacity of somebody by using these tests? What are you looking for?
Two tests that were used are standard psychological tests. One of those tests, the Minnesota Multiphasic Personality Inventory, is 567 true-false questions. It is standardized on a psychiatric population and includes a variety of different scales that are descriptive of certain aspects of personality. It is a test of general psychopathology, of serious, if you will, mental disorder. The Milan is in the same format. It's a series of true and false questions. The Milan is shorter and is designed not so much to address general psychopathology, but rather more what's known as characterological disturbance or personality level disorder. So that's why I use both of those tests, because they're looking at different aspects of an individual's overall functioning. Those two tests are widely used in our field and generally have been found to meet evidentiary requirements.
Okay. And when you administer those tests, there are 500 and some odd different questions, yes and no questions, and you just mentioned that there were two sets of questions, one for each kind of test. What kinds of conclusions were drawn from the first test? What you said that was the what test? The
Minnesota Multiphasic Personality Inventory. I reported on both of those tests in my report and described sort of a compilation. My description of the results was in terms of both tests. Those tests are tests that are essentially compare the individual's responses with a standardized sample. So people that score a certain way on that test are compared to others in the normative sample who score similarly. Those individuals who score similarly have certain attributes. So for instance, somebody who was scoring high on scale 2, which is the depression score, is scoring similarly to individuals who have a high level of depression, for instance.
Okay. And based on her score, what kinds of conclusions did you draw? Because when I read the report, it seems like you came to some conclusions that described her as mania and hypermania and psychotic, and some of the terms that you used, delusional.
Let the witness testify as to his conclusions, Mr. Gibson.
Okay. Was there a part of the examination when you examined her that she had been in psychiatric treatment for going back to her 20s?
Ms. Martin reported to me that she had a what was described as a nervous breakdown in her 20s, and there was some treatment following that. There was actually an error in the report, which subsequently was corrected by a letter submitted to Mr. Vetter, which is in Mr. Vetter's file. Because in the conclusion section of the report, I said she had been hospitalized. I do not think had been hospitalized for that.
But nevertheless, she retreated treatment.
There was some treatment at that time, but not hospitalization.
Part of the report that kind of well, let's just say bothered me, because I had known Miss Martin and some of
Mr.
her.
Gibson, just ask a question, please.
Yeah, well, when somebody is described as manic or hypermania, what does that mean?
Hypomania refers to an elevation of mood that is characterized by a high level of activity, an increase in certain kinds of behaviors, an increase in goal-directed activity. Individuals may become involved in many different kinds of activities or projects. As that behavior increases or becomes more exaggerated, it may be termed a manic episode, which is really sort of an overall exaggeration of hypomania. So it is an elevation of mood, increase in behavior, and at times the inability to really focus on finishing tasks at hand, because too many tasks are at hand as it gets to the higher, more exaggerated levels.
Would that have anything to do with any kind of sleep deprivation, staying up 4, 5, 6 nights in a row without getting any kind of sleep?
One of the first rank order symptoms of a manic episode are individuals who do not require sleep and may, in fact, stay up all night. Or as I describe to patients who experience that and find it to be a normal part of their existence, I'll often say to them, well, how many times in my 61 years do you think that's happened to me? Oh, well, I'm sure that happens on a regular basis. Not once. Have I ever been able to stay up 24 hours and without requiring sleep? And that's a significant symptom if that is repeated over time.
So someone that writes about her episodes of staying up for 4, 5, and 6 nights in a row would be part of what you would expect from someone that had this kind of, what did you call it, mania?
It could be a sign of a manic episode.
Okay. If someone continues to do this kind of thing and not get the necessary rest and sleep that most of us in the human race require, could there be any negative effects of her personality as a result of not getting this kind of sleep for continued periods of time, let's say years of this kind of activity or non-activity or non-sleep?
I'm a little unsure what you're asking.
Well, what I'm asking is if a person has a propensity to stay up hours and hours and never get any sleep and has the care of a 4, 5, 6, 7-year-old child, it would just seem to me that that child could be at risk if she is not able to get any kind of rest and therefore might turn her head or not acknowledge the other things that are going on in the home under her watch. Is that accurate?
That if someone is sleep deprived, that they may not act adequately in their parenting role? Is that the
a possibility? Yes.
That would certainly be a possibility, that sleep deprivation generally decreases one's overall level of functioning.
Okay. As I was reading your report, what kind of bothered me, as you know, we both have a 7-year-old child, and part of what you had written as one of your conclusions was that this mania or hypermania, or if she was to have I think you wrote a fluid, whatever that word was, episode of this psychosis, that she could not be a good role model for the child. And as a matter of fact, didn't she write that she could be actually dangerous to my child if she had one of these episodes?
What I indicated in my report was that if, in fact, what appeared to be a mood disorder spiraled out of control into a florid manic episode, such individuals can be dangerous to others and specifically to children if that were to occur. In that context, I made certain recommendations for treatment related to that.
So, am I hearing that if a person goes 4, 5, 6 nights without getting sleep and could be irritable, and if the child makes a move the wrong kind of way, I mean, what do you mean by being dangerous to the child? What kinds of things could possibly happen?
Individuals that are in a florid, psychotic, manic episode may not be in touch with reality, may misperceive situations that they're involved in, and may take actions based on their misperception that are not appropriate to the situation, and so they're not able to be responsive to an individual's needs, and specifically, potentially, to the needs of a child.
So then, if there was another individual in the house that was involved in inappropriate activity with the child, and she'd been up for nights and nights and nights, could it be that she, even as might be witnessing something like that, would not be able to fully comprehend and evaluate what was going on? And in that sense, the child could be in danger, not only by her, but anybody else in the house that's acting inappropriately. Would that kind of fall into what you described? Would that be?
Again, generally, I would say if somebody is out of touch with reality, they may not respond appropriately, and they may misperceive. So that certainly is something that would be a potential if somebody were in the midst of such an episode. It's not clear to me that was what I was seeing. What I was predicting was that possible problem if the mood disorder was not taken care of.
In reading your evaluation, you mentioned that what you would suggest and actually recommend very strongly was that Miss Martin, because of this hypomania and psychotic behavior, is it not true that you recommended that she needed long-term psychiatric care with a well-qualified psychiatrist? Was that not part of your recommendation?
I recommended that she consult with a psychiatrist to establish a treatment regimen for what I felt was a mood disorder.
And didn't you also recommend that, in your opinion, that Miss Martin would be well served to be on some kind of, I think you used the term, psychotropic drugs?
Correct.
And didn't you also mention that her propensity to self-medicate herself with marijuana, as she has admitted that she does, would not, the organic nature of who she is and her belief systems, that this would not be the kind of drug necessary to control her mood swings?
My recommendation was that she consult with a psychiatrist and discuss with that psychiatrist medication options in lieu of what I saw as the possibility of self-medication. In your conclusion, then, if the court was to then take a look at some of the things that she's been doing, that would illustrate to the courtroom these kinds of behaviors, psychotic behaviors, delusions of grandeur, self-elevating. If in fact you wrote
that these kinds of things would be expected of a person like her, especially if she did not receive the psychiatric counseling and psychotropic drugs that you recommended that she have. Would you then, if it was then shown that she was doing the kinds of things that your fear of that kind of mania and psychosis, if it was illustrated that she was doing those kinds of things, does that not make you a prophet?
I've never thought of myself as a prophet. I do think of myself as a psychologist. And there are certain predictions that can be made if a mental illness is not treated accurately or becomes out of control, as it were. Certain common symptoms. Those are some things that anybody in my field could predict, regardless of their status as a prophet or not a prophet.
So if Ms. Martin was looking at your evaluation and recognized that the kinds of things that you're testifying to at this moment might have an effect on whether or not she can remain as the custodial parent, even temporarily, even for another day, would it be such a far stretch that such a person might then go to a medical board and try to have your findings thrown out? Would that be an episode of psychosis?
I think it's probably inappropriate for me to comment on what her motivations may have been for reporting her concerns to the state board. That anyone that receives services from a licensed psychologist has a right to do that. And there is a process that then is gone through, and that occurred in this situation. So I'm not sure it's appropriate for me to comment beyond that on what her motivation might have been.
You did, however, comment on her having this over excitement and grandiosity and several different kinds of projects, juggling them all at one time, never ever completing any of them, as part of your recognized symptoms of this hypomania and so forth, correct?
That would be a common type of symptom.
Okay.
Yes.
So you also mentioned in your report that she had mentioned that she had moved so many times that she couldn't remember all the different places that she'd moved. And wasn't there a comment saying that that kind of movement with my son would then have some kind of negative effect on him? Would you like to comment on that?
All right. I'm a little unclear of the question. Is the question, do I believe multiple moves could potentially have a negative impact on a child?
That's correct.
I do believe that that can create instability for a child and may have a negative impact. Yes.
What kinds of negative impacts? What would you, if a child was behaving in something that was out of the norm in his personality, as far as his attitudinal behaviors, his stress levels, his inability to have some rational thinking, outbursts, bedwetting, going potty in his pants. Would those be some of the kinds of things if she was, because of her psychosis, not being able to see what's going on in her own house, and somebody in that house was doing some things that would encourage that kind of behavior? The moving around and the potty problems and all that, could that be related some kind of way to what your diagnosis was?
Those would certainly be symptoms of distress on the part of a child. Those types of behaviors would be clear symptoms of emotional distress. Those are non-specific symptoms, but may be related to the issues that are being raised here. One would have to further assess it to be sure.
So when you say further assess it, would that mean that it would be appropriate to have the child seen by a mental health professional to try to address the genesis of what some of these problems that he may have? If her behaviors, psychotic behaviors, are and she has the care of a now 7-year-old child, and this has been going on for a number of years, do you think it would be appropriate to have the child interviewed by a mental health counselor away from her influence, so that the child might be able to have a grasp as to what's going on in his life?
If the child were exhibiting those symptoms, my recommendation would be that the child be assessed either by their medical provider or a mental health professional to see if it was appropriate to have mental health treatment.
Also, doctor, this kind of mania, psychotic behavior, excitement, self-aggrandizing delusions, would that play a role in her believing that the child does not need to have medical examinations and shots that are required by school districts to be able to immunize a child against childhood diseases that could be passed on to other children? If the parent refuses to do that because of this kind of grandiose thinking that he doesn't need that because, this is who I am, would that be detrimental to the child and also detrimental to other children that might be in contact with the child who she refuses to have shots taken because of her belief system?
I'm not sure that I addressed with her any of that concern specifically as to why a parent might not get immunizations. So it's not something that I can address specifically in this case. I don't believe I ever asked about that, or that was not a direct focus of my inquiry.
In general, on any child, with a person that has this kind of psychotic behavior that might think that the child, for whatever reason, doesn't need these kinds of shots.
Well, if a parent is psychotic, by definition, that means that that parent has a distorted view of reality, so their cognitive productions are affected in a variety of ways, and certainly that could be a potential way such cognitive productions were affected or certain behaviors justified, if we're assuming that there is a psychosis present.
In addition to that, if this sign of psychosis that's present and the child was directly involved with her on a day-to-day basis, could that psychosis have an impact on his thinking in terms of him not wanting to go to school?
I think anything's possible in that situation.
So if she had the child to believe that him going to school would put him into a situation where he could be bullied by other children, based on her sleep deprivation, based on this manic behavior, hypermania, and all these kinds of things, could that be fostered by her onto the child so that he starts to form a belief system of that and start to manufacture in his own mind this kind of behavior?
If the child is being, if there's an attempt to influence or impact how the child perceives their school experience or what to expect at school, certainly a child at that age could be so influenced by any parent who was aggressive with them in terms of trying to color their expectation for the school experience.
Would it be beyond the scope of a person that has this kind of psychosis to accuse somebody of have an abusive nature as far as our relationship, when in fact there may be abuse going on in the home by another individual towards the child that makes him go potty in his pants and doesn't want to go to school. Would that be in the realm of possibility if she had that kind of influence based on the things that you've been found and things that you discovered? Not that you would know any particular incident. Like I said, you'd be a prophet. But could that have some kind of...
Again, if we're assuming psychosis, almost anything is possible, because by definition, such individuals are not responding rationally to their environment. So I think with that assumption, that would be possible.
If these kinds of things, without at this point in our case any specificity as to what exactly these things are that I'm trying to relay to you, if the child were doing other things, pooping his pants, having a retaliatory nature towards the mother and the other individual in the house, as far as acting out, having temper tantrums, displaying anger, fighting, hitting, these kinds of things, would this be because of the effect of all these things that are going on in a 7-year-old, 5-year-old, 6-year-old, 7-year-old mind? Would it be uncommon for the child to want to fight it, to be angry about it, to have behavioral kinds of episodes?
One would expect that there would be some behavioral signs and symptoms, some emotional sequela of such an environment on a child. So you would expect some kind of symptoms to emerge, be that encopresis or enuresis or aggressive behavior or what have you. You would expect some kind of emotional and behavioral sequela.
Would sexual abuse be one of those kinds of things? If it was found that this was happening, would that trigger some of these anger episodes, some of the potting in his pants, some of the not wanting to go to school kinds of things?
There are a number of symptoms that can be associated with the sexual abuse of a child. Those are symptoms that have been associated in the literature with sexual abuse. They're nonspecific, but they certainly have been associated with that experience.
Would it then be uncommon for a person that has this kind of psychosis that we're speaking of to want to then protect the perpetrator of these kinds of things and keep the child from going to school so that it could not be discovered? Would that kind of psychosis, is that a possibility? Like you said, anything's possible.
I'm a little confused. Are you asking if the individual is aware that the child is being abused, would they potentially attempt to
prevent the child from having any outside...
That child can't report the abuse? Is that what you're...
If these kinds of things were going on and the child was being combative, the child was angry, the child is talking about not wanting to go to school, then holding the child from school, moving all of the time, would these be some kind of indications that may be related to the psychosis and now has been, the child is now so involved in this as to his psychological temperament himself has been affected?
Objection, Your Honor. Dr.
Dr. Johnson doesn't have his crystal ball. We could hypothesize all day long. He hasn't had contact with the child. Is this...
Have you had contact with the child, Dr. Johnson?
I have not.
So at no time during the pendency of this case have you had contact with this child?
I did not. Oh, Dr. Williams did. I did not.
All right. The objection is sustained.
So let me ask you this then. Based on your observation, and you mentioned that Dr. Williams was a contractor under your authority, and he had this observation. A person that has a significant intelligent quotient, in other words, a very smart person, but at the same time has these kinds of psychoses, would that person, in your opinion, be able to try to protect a child in the home that may be experiencing these kinds of negative episodes?
Did you understand the question?
I think so. If the question is, can an individual with a psychotic level disorder act protectively towards a child?
No, I think it started with Dr. Williams's observations.
Yeah, you had mentioned that Dr. Williams, or the judge asked you, did you directly have any contact with the child? And you said no.
Correct.
But you also said that Dr. Charles Williams, who was contracted under your authority, did.
Correct.
And so, based upon you having authority over him, he reported his analysis to you, correct?
Correct.
Okay, so then you would be aware of anything under your employ that may have occurred between Dr. Williams and Ezekiel Gibson, correct?
Correct. I have Dr. Williams' report, and I've reviewed that report.
Okay.
Correct.
So my question then is, if a child is being abused in an environment with a psychotic person who basically may understand or may not understand the abuse that's been perpetrated on the child in the home, would the child then act erratically based on your years of experience in psychology?
What's the correlation between Dr. Williams's observations and the
Well,
course?
the doctor observed and I have this report, which it's okay. It's not a detriment to her, but we do have a copy of Dr. Williams' parent-child observation. That would be Exhibit 24.
That's the one dated December 30th, 2008.
Right, and basically, I mean, there's nothing there that stands out except for when she kept continuing to call my son a liar, which is in the report, correct? They were playing a game.
Right.
And she suggested repeatedly that he was cheating.
On 5 different occasions, accused her son of cheating.
That's correct. So if she's doing that kind of thing in a controlled environment, like in the Vancouver Guidance Professional Clinic, under that circumstance, would it be a far reach to conclude that what might be happening behind closed doors could even be worse?
I suppose. I'm not sure what you mean, but again, I think it's under the generally, is it possible? Yes.
Okay. So if a person has these kinds of episodes, would a person that lives in the home with her as a companion, as a roommate, if they have a combative situation, arguing, name-calling, wrestling, karate kicks to the chest, would a running after her after an assault with her trying to flee and getting her in a headlock and all kinds of things, if this kind of activity is going on, and she has not been to a psychiatrist for any length of time to deal and address with these issues, and if this same person that has a history of doing these kinds of things with her is still in the home with her, and these issues have not been addressed, is that kind of what you mean could be a florid episode that might be dangerous to the child, if these kinds of things are going on?
The behavior you described sounds like it could be dangerous behavior to the child.
So if it could be demonstrated in this courtroom that this behavior has been going on for a number of years, as in her own words, in a book that she has called Eating My Way to Heaven, which has been introduced as to evidence.
No, it hasn't, not yet.
Will be introduced as to evidence. If it was demonstrated that these kinds of things have been going on for years, and she hasn't had the treatment from the psychiatrist that you addressed and the psychotropic drugs to be able to control her mood swings, and it has been unabated, would it be fair to say that just logic would dictate that these kinds of things could possibly be happening in the home today? Not that you're at the home, but would it be a possibility that these kinds of things, if they haven't been addressed, could still be going on?
That would be possible.
So if that was possible, then the child, as we speak, is in a dangerous environment.
My concern when I wrote the report was that if the symptoms were not dealt with, that it was possible the child could be in an environment that was dangerous.
Your Honor, might we be able to get the book, which is on the list here, Eating My Way to Heaven book, which is Exhibit 35?
I object to this exhibit, Your Honor.
I don't know what he's requesting. What are you requesting, Mr. Gibson?
I'm requesting, the good doctor said that it would be possible for some of these behaviors to continue. If there was, in her own words, a book that over and over and over and over illustrates this kind of behavior that the doctor says is possible, I think it would be incumbent upon the court to look at that evidence.
No, you can't offer that book into evidence in that manner, Mr. Gibson. Next question, please.
In that manner?
Yes, sir.
Okay. But that does not mean that I can't enter into evidence, just that not in that manner. That manner is
I'm
what you're...
objecting to it going into
That was
evidence.
my statement, yes.
Okay, fine. I can go with that. If there had been in your report, wasn't there a mention of suicide?
If I might take a moment, Your Honor.
Go ahead.
What Ms. Martin reported to me in interview was that there was a period of time when she was a teenager that she had some thoughts of not wanting to live.
If it could be demonstrated that she speaks about this and writes about it numerous times in her book, would that, when she was not a teenager, but more recently as a few years ago, would that then tell you that some of the psychotic behaviors that she said that she was treated for but not hospitalized for as a teenager are still ongoing?
Objection, Your Honor. He's quoting from a document not in evidence that was written 13 years ago.
The question was, if it could be demonstrated that these suicide episodes in her mind, whether she carried them out or not, but we're thinking about them. Now, you have to understand, we have a child.
Please continue with the
Okay.
question.
And because we have a child that you said could be in a dangerous situation if she has a florid episode of psychotic behavior, would you say that suicide would be one of those episodes if she was thinking or contemplating about it, especially when she has the care of a 7-year-old child?
People that are psychotic can also be suicidal. There's a higher level of risk for psychotic individuals who are suicidal because their behavior tends to be so unpredictable and at times bizarre. So being psychotic does not rule out suicide as an area of concern.
You mentioned that having a florid psychotic episode could be dangerous to the child. If she was having one of these florid suicidal contemplations, wouldn't that be exactly what you mean by dangerous to the child?
Certainly that would be dangerous to the child.
Your assessment then of Ms. Martin would then dictate that because we have a child at risk, the respondent wants to make it seem as if I'm the person that is abusive, when in fact, based on your observation and diagnosis and of the events in her hypermania and mania and suicidal tendencies and psychotic behaviors, and we have a 7-year-old child in the home that's not going to school, that is not allowed to socialize with other children and these kinds of things to protect him from outside inquiries. Do you think that's a healthy environment based on your long years of your profession? Is that a healthy environment for a child to be in?
If my understanding of the question is correct, is it a healthy environment for the child to be in with a parent who's experiencing a psychotic episode?
Correct.
That would generally not be considered a healthy environment.
So if the child is in that environment as we speak, and because of her psychosis and sleep deprivation and all these other kinds of things that we've talked about, would it either enable her not to be able to see such abuse right up under her nose, or she does see it but is not able mentally to be able to evaluate it in such a way that she could do something about it, would that put the child at risk?
Yes.
So in conclusion then, Dr. Johnson, if it could be demonstrated that this is the current behavior, her constantly moving, her not, well, let's address this. You mentioned in your report someplace about how her continued moves all the time is not healthy for the child, and that the child should be enrolled in school. And there's a report in there somewhere that suggests that you didn't think, based on her behaviors, that she would enroll the child in school. If it could be demonstrated to you now that the child is not in school, I don't want to use the word profit again, but that's kind of incredible. Would you say? I mean, is that something that's...
I'm wondering if there's some confusion going on here between my report and the family court report.
I was just going to ask you if you could refer me to where you make reference in your report to this school question.
My report was specifically a mental health assessment of Ms. Martin. There was also a concern family court had related to having an interaction study between Ms. Martin and the child, so we also did that. But I don't recall specifically dealing with school issues. I'm wondering if that was...
No, and that was my question. I understand that. I understand that that's not the situation. My question to you is, with her mental condition, let's just say, and all of the things that we up to now have talked about, her keeping the child out of school, when this judge, Judge Ruley, has ordered her to enroll the child in school, if the child is not in school and he's been assessed as being a brilliant little boy, all these kinds of things, he obviously should be in school. If she's keeping him out of school and with her psychosis and psychotic behaviors trying to homeschool him, would that be something of concern?
It would be of concern, and would be something that I would want to be very careful about in the situation.
So then, what would then your total assessment of Miss Martin's mental condition be based on your office and those people that were contracted in your office and your observation and others? What is your assessment of Miss Martin's mental state of being if she has not addressed any of the things that you have said that she needed to do, psychiatrist, psychotropic drugs, all these kinds of things?
At the time of my evaluation, and Ms. Martin was actually seen in our office, I believe in December, some months before the report was produced for Mr. Vetter. At that time, I believed that she had a mood disorder. I believed that she had a substance use disorder, and my recommendation was that in order to be more of a resource for her son, that she obtain treatment for those conditions.
So if she has not received that treatment with these kinds of mental issues, does she just get better on her own?
Typically, these conditions require professional intervention, particularly the issue related to the mood disorder. Long-term substance abuse, obviously somebody can stop using substances on their own, although the chance for relapse is substantially higher if they do not get professional intervention.
Thank you, Dr. Johnson. No further questions at this time?
Okay, we'll take a 10-minute recess before we have the cross-examination.
Thank you, Your Honor.